Come up, Mr. Jones.
Mr. Mayor is in Cancun until Monday next week, Judge, so he's not available this morning.
I
So I'm kind of filling in. I have had a chance to look at this violation report regarding Ms. Blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over, and there's absolutely no excuse for the missed blows.
Pause right here. This is what zero tolerance actually looks like in court. Missed tests aren't treated as technical mistakes. They're treated as intentional avoidance. Judges see missed blows the same way they see failed tests, because the system assumes if you miss it, you're hiding something. Question for you: should courts allow flexibility for real-life issues, or is strict enforcement the only way probation works?
How many missed blows do we have?
That's 19, Your Honor. That's seven, within that 7 are included. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. You know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzer?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Oh, please,
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate for
go to sleep early, man.
Test, and he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor, I will do anything. I'll even go on that drug, Ankemon. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor, it's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock, and I still did the ones later on when I would wake up, and they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond?
Of course.
Oh my gosh. Why? Please, I'm trying to do everything.
Goes with you.
Oh my gosh.
This is a turning point. The bond just doubled, and that's not punishment. It's leverage. Judges increase bond to force compliance or quietly ensure someone stays detained if violations keep stacking up. Notice the language. I'm done. That's a judge signaling the patient's phase is officially over. Audience check. Do you think this defendant talked himself deeper into trouble here, or was he already out of chances?
The bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling, and I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 75 or 2, Judge, for both.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't. But, fine. Because, Mr. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime? There's such a thing as lifetime probation?
Yes.
Whoa.
So that case, well, I'll let you do the talking.
No, he did his time and he got out and lifetime probation out of Michigan. So that's what's happened. I believe they got.
So how what would, aside from like a murder case,
So he was
what
charged
would
with
garner?
murder twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I
twice.
was about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, even threatening to murder.
Let's break this down, because this part is confusing fast. Lifetime probation, interstate compact issues, possible ICA holds. This is a legal minefield. If Michigan revokes probation, Texas can't just ignore it. That's why the judge keeps circling back to public safety and flight risk. This isn't about one case anymore. It's about whether any court can trust him at all.
Murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA. But I don't have the documents, which is why I can't present them. If there's an ICA hold, he is ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say. But if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor?
Of course.
Okay. After we talk about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though.
I understand that.
That's why he said, okay, it's fine. He said it was fine.
Quick question: is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've not
This month.
heard. Okay, and then so there's not been a hearing on that yet, right?
No. But that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up as. I took the plea
What
deal.
are you on probation for?
The armed robbery, conspiracy to commit armed robbery. I did 5.5 years, came home off lifetime probation. And to continue what I'm saying, I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday. I still showed up to court. and we got locked up. So there's no flight risk in this whatsoever if I'm been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, you know, and they give you a curfew,
Yes.
and you don't abide by the curfew.
I was working, Your Honor. That's why the judge has extended, because they had my probation curfew time at us. I forgot what time they had it as. But I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge, and he extended my curfew. He was like, okay, you've been working. I said, yes, I have documentation of new work. So I'll show all my documentation, and he said, okay. So the stuff he's mentioning violations for, they already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. Obviously, I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge, and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus, that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taken care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year. Your Honor, he's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for if since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Okay. Texas Code of Criminal Procedure 17.03, NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/20/21. Concurrently charged with murder, which was dismissed. No holds. Defendant is not innocent, and defendant is alleged to have gone to complaining witness's home and pointed a gun at complaining witness and complaining witness's 3 children because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon where allegedly a gun is pointed at kids.
This is the emotional peak of the hearing. When allegations involve weapons and children, everything changes. Judges don't need proof beyond a reasonable doubt at bond. They need reasonable concern. And right now, that concern is screaming off the page. Audience question. Should allegations alone be enough to deny bond when public safety is on the line?
I mean, the way your mannerisms.
I would say something, y'all. That's why.
But don't, though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like somehow, sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. Mr. Thurman, you scare me, man.
Can I scare you, Your Honor?
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful for whose safety if I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond, and I have not been into this no courtroom, but on the jump shoot, I should say. Your courtroom, anybody's
You want
courtroom.
me to reward you for being?
Saying, but you say you're in fear. You say you're in fear for safety. That's what I'm saying. Like, who you're in fear of, I have not been into any trouble whatsoever. I've been squeaky clean. Just I bond it out.
And Your Honor, to
You
your,
don't get rewarded for being a good person out there. You know what I mean?
I
You're
understand.
supposed to be like that anyways.
I understand that wholeheartedly, Your Honor. I'm just saying, when you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you, that should show you some type of sign. Like, okay, he's not been doing anything wrong. So where is the fear come to play? That's what I'm asking you.
The fear is really because, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops. And then when they get out there, they turn into different people. It's like Jekyll and Hyde. And I don't want that. Like, I don't want someone out there to suffer because we let you out. I let you bond out. You've got an armed robbery, you've got an ag assault. You continue to violate conditions on those bond, right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
And Your Honor, you keep saying violate, like, if I was in violations they have on file, by the way. Those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from the other job, so I started a new job. For me having a felony in my position, and just call it what it is, a young black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard. Any shift they open up for me, I'm going to take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work. I have to eat. I have to have a house to live in, like anybody else here. So you keep on bringing that up. I'll keep saying, I already talked to the judge about it. He granted it already. He let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You saying threat to your fear, which is understandable. Everybody gonna have fear, but I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you say, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to it than what you're just reading on that police report. It's always gonna be video cameras and house ring cameras, body footage. It's going to be a lot more other things that you're not going to be able to read off a police report, which is understandable.
Just too much blood, Mr. Thurman. I'm sorry. I can't set you on. It's just too much. I'm sorry. Hey, this isn't.
Do not walk away.
This isn't.
I said, okay, it's fine.
I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best trying to. Y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble, and you're a threat, and I'm a threat to society. Really, for a whole year I've been out, and they just not issue a warrant for me just now recently, and I come to turn myself in, and I'm a threat to society. And people, you fear me for what? From turning myself in, show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But you're a threat. You can let go of me, sir.
Stop. You can let go of me. You do not tell me how to do my job.
Just you can let go of me. Grab my arm too tight.
Guys, relax. Relax.
All I said, look how you grabbing me up.
Back up.
Look how they grab me. I said, let me go a little bit.
You gotta calm down.
I'm calm. I asked him a question. I asked him, I should let me go a little bit, sir. That's all I said.
That moment right there, that's the exact second control was lost. And judges noticed that instantly, whether he meant to or not. Physical resistance or emotional escalation in court confirms the judge's worst fears. This is why lawyers always say, the case isn't just your charges, it's your behavior in the room.
Open the door.
That's all I said. What do you make smile? Cuss you out or anything? You said I'm all type. You just wrote me. You know what I'm saying?
So he already waived, so if he
did.
holds it, then it's.
I can't.
I'll go talk to him, but once again, Judge, understandably, I think he's I know that he's frustrated, I believe.
I understand, I get it, and I would be too, but I can't, that's just too much blood. It's too much, you know?
It looked like there was.
Even, you know, and I'm gonna tell you, even if he didn't have those bond violations, that'd still be very hard pressed to even, you know?
No, and I was curious because when she brought it up, it was a little bit older, and so I was wondering why.
Do you know, are they gonna come get him?
Well, they're gonna get him. I was trying to figure out why now, and they were just having back and forth.
But here's the problem, so he hasn't made bond on those cases, so we're sitting anyways.
Yeah.
He has not? He said he did.
No, he's not made bond on those cases.
He's been in jail for a year?
No.
He may have, but they revoked the bond.
Ah,
Yes.
So he's sitting there, and I
There you go.
didn't have the heart to tell him right now that the 14 days is not gonna apply.
Yeah.
Because
I gotta do that.
Well,
I really.
would
I
imagine.
will, I'll let him know.
I'd imagine it's gonna get resolved because it's one of those. It's a bizarre. So we revoked. Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events because the only thing the court sees is that they revoked
So-
the probation, which was caused.
Please
by
let him
events.
know that the 14 days hasn't kicked in, and it will not.
It will not kick in.
Resolves,
Right.
and either he resolves the cases.
So which one does he need to resolve first in order for,
Well, for the felon possession of the weapon, there's. Hold on, I don't want to.
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been separate jury trial at least
four
Really?
times?
4 times. 1,
Yeah.
2, 3, 4, 5. Yeah.
5 times, Judge.
Next time is January 6th, 2025. But he's held on 55,000 bond for the ag assault and 55,000 for the felon possession. So he has to come up with 110,000 for.
Wait a second, so
So it doesn't matter what you did today.
can't, even if I gave him a bond today, he would still have to make those bonds.
110,000.
So my question now is, when did that warrant for the felonies pick, because he's saying he's been out for a year ever since this
I'll
ag
blame
assault got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan
Well,
revoked.
I should
Oh,
be-
no, it doesn't, but we don't know that for sure.
Yeah.
Because there's no notes that reflect why they revoked the bond. It just says, court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay,
It's remand custody, violation report, but that's not a revocation. Yeah, because,
it's a violation report from Michigan?
no, for me, so remember when I said the newest violation was on November 1st for all the curfew violations?
Mm-hmm. Is that from here?
Technically, that could be the reason why they revoked instead of Michigan. I don't know, because I don't have the document. And
Yes.
So.
But he hasn't gone out to Michigan to, I guess, take care of.
For that
The
one,
current bound violation.
2023, so it would have predated.
I
It
get
just
you.
takes some time for them to do it, which is why I hate it, because they should have waited to file it. But whomever originally had him, well, actually, if he said he was in the courtroom, when it happened. Yeah, sheriff's office. So they should have known to wait and file.
I got you. Okay.
Okay, well, I guess reset to track locals. Oh, man,
Don't set it to January.
I'm not. When in
So-
December would you like to touch base?
Now, my question now is, does it matter for us to touch base if his locals are gonna be reset far out? What's the
Yeah,
point of?
Yeah, we have to,
You
gotta
do
keep
like
it.
a plea deal, pre-trial,
Ah, makes sense.
or mid-trial dismissal. Because Troy Locklear on the one of.
So let's do this. Do you see a date for like a pretrial motion or a pretrial setting for them?
Trying to file a motion.
Highly doubt it,
File a
Judge.
motion, but I mean, there's nothing between here and there. Judge Jones, I would be surprised if they set another
Okay.
So if you want to talk to Troy-
18th, 17th of December?
17th of December.
Finner? Is it Troy Finner?
No.
Troy Locklear. So hold on, December 17th.
I'll find out.
Yeah,
All right.
okay.
17th or 18th, whichever one of those days works for you, I'm good by it.
I live in this building, you tell me.
And then if you have any problems with him, we can bring him back out as far as just tracking locals, meaning that just let him know they revoked the bond. And essentially, the time here, it's kind of told until he either gets a bond reinstated, post-bond, or somehow deals with the case.
Because the bond is set, so if he can come up with the money, he can. But I'll put 17, and then if you want it sooner or a couple days
Gotcha.
out, let me know.
Sounds
See you
good.
tomorrow for.
Yes, sir.
Okay,
I think
Thank you, Judge.
we are done.
Maybe excuse you.
Oh my God.
And Your Honor, I filed a dismissal on moves. I emailed.
come up, Mr. Burrows.
Also, she sent me an email from,
If anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also,
You went the day before court.
and I also went before.
Judge, she's been going. She's been going before even the last court date, and we you know,
Prove it.
I can text you.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I got an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, you know, attempt to go to class. So she's been going. She did already take a test, and this is one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
Now I'm trying to text you.
Texting who?
The instructor, like what I'm supposed to show you. Cause I don't have no proof, like I don't have nothing.
Tell me, what have you done?
I went to the class,
Okay. Which class did you go
the
to?
GED resource.
Okay. And what, because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining on how everything's gonna go, and I was gonna finish everything else Wednesday when I was gonna go, but the class was canceled.
Who is the provider that you have?
His name was,
Grab me a phone number, because I'd like to call them right now.
I have a number for you, Judge.
And go ahead and put this on.
Oh, yeah. Charles Jackson.
Mr. Jackson? Yes, my name is David Pleicher. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. Sir? I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a probation where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED content. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question, depending on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I worked with people that have gotten the GED in 3 weeks. I worked with people that have gotten the GED in 2 years.
Oh, yeah. I can't do 3 years. That's too much.
Well,
I know. I'm kidding.
No, I understand that.
She's been faithfully attending, though. Yay or nay?
Yes.
Okay. Great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay, so I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got, like what he's saying, if you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take care.
You too. Thank you, sir. Bye.
And now we shift tone completely from punishment to rehabilitation. This GED moment is rare courtroom humanity. The judge verifies facts, calls the instructor, and then rewards effort with time instead of cuffs. It's a reminder that courts don't just punish. They test who's actually trying. So ask yourself, how many defendants lose simply because they never bring proof?
Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Good job. All right. Good morning, sir.
Thank you for seeing me, Judge.
Of course.
Come before you. I don't really know.
You're 18 years old. Have you been to prison before?
No.
Mr. Romero, do you want to take a guess what in God's name they would do to you in prison? You have had already in September, you get on probation. 3 months later, they file a motion to revoke your probation. They keep you on your probation. They extend, or they did whatever they were going to do. And now 2 months to 3 months later, you're back yet on another revocation. Do you have any clue what they would do to you in prison? You and your 18-year-old self. Do you know what they do to 18-year-olds in our Texas prisons? Take a guess what they do to 18-year-old kids in prison. Take a guess. I read stuff that had me damn near in tears because it was so bad what they do to certain people when they go to Texas prison in Huntsville. They literally treat you like a freaking rag doll, pass around like it's a freaking cigarette. You are chattel, meaning a piece of property. That's only the half of what they do to little young children in Texas prisons. You have now are on your second motion to revoke. It's only a matter of time before they say, you know what, this little dude don't get it. Let's send his ass to prison for 3 years. When that happens, you'll be crying for mommy and daddy. And if you don't believe me, start asking the people in jail. They'll tell you. I'm happy to roll it whatever you want, Jillian.
Let's do that. Thank
If
you,
you want to
Judge.
do a week, 2 weeks, whatever you want.
That's fine.
Get a clue before it becomes too late and you become a piece of chattel. Okay?
All right, sir. Oh, it's okay.
Blake Jenkins. Mr. Jenkins, you're charged with 2 cases. You're charged with 2 counts of terroristic threat. Was he on bond for this case and then he picked up a new case?
Yes, Your Honor, it appears so, that he was on bond for the.
He was literally on bond and then a week later he picks up a new case.
Can I say something?
Don't. Are you here with anyone today?
Sure.
Yes, yes, it appears correct. He was on bond and then he picked up a new case.
So, as what I see, he picks up his first terroristic threat. We gave him a PR bond on November. So, tell me if I'm wrong. So, check this out. Tell me if I'm wrong, but it looks like both of these were just both 2Bs, meaning warrants had been issued, and he had not been picked up. This is Jenkins. And it looks like we picked him up all at one time, and he was given a PR bond on November 13th.
On the terroristic threat?
On both cases, they're both terroristic threats.
Yeah. Yeah, because it would have taken a month for him to get arraigned, so it must have been.
Yes, Your Honor, that's correct. There were.
So he was not on bond.
No, he was not. There were both 2Bs, Your Honor.
Now, do you guys know the relationship of Ryan Kalal?
He was just a member at the gym that the defendant attends.
Okay, so let's just go ahead and do probable cause on both cases.
Okay.
So Mr. Jenkins, you're charged with 2 cases. You're charged with 2 counts of terroristic threat. One is against a family member, so on that one, you're facing up to a year in jail and or a $4,000 fine. Your other case is just against a garden variety civilian, so on that one, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
So for the terroristic threat involving a family member, the complainant and the defendant are brothers.
The officer was dispatched to a residence in Harris County, Texas in response to a family disturbance. The defendant was removing the complainant's belongings from the residence and putting them in the back of his own vehicle to prevent the complainant from getting his things. The complainant tried to remove his things from the back of the vehicle when the defendant stated, "I will kill you." The complainant was in fear for his life when the defendant said this. The defendant also later texted the complainant that if he touched his things again, that he would cause him severe pain. And then for the other terroristic threat, on October 26, 2024, the officer was dispatched to Crunch Fitness in regard to a terroristic threat. The officer made contact with the complainant. The complainant, the manager at the gym, stated the defendant was involved in verbal and physical altercations with other members, and multiple complaints were filed. The complainant stated that the defendant's membership was canceled due to the issue with other members and the defendant making threats. The defendant then continued acting aggressively after finding out this information and caused a disturbance by screaming and cursing loudly. The complainant told the defendant he needed to leave and not return. The defendant became more agitated, left the business, but returned multiple times. The complainant stepped out with the defendant and told the defendant repeatedly not to return. The defendant responded multiple times he was going to come back to the business and kill the complainant.
All right. So, Mr. Jenkins, I'm going to find that there's probable cause to go forward on both of your cases. I'm now ordering you on both of your cases not to have contact with each of those witnesses and not to go where they either live or where they work. Do you understand? In the first case against your brother, a protective order has been issued. So I would get to know that protective order, because if you violate the protective order, they will file additional charges against you. You violate those conditions, I can hold you at no bond, zero bond until this case is over with. And I want you to know that I will protect every single person of Harris County by all means necessary. And if that means putting you in jail, locking you up at a $100,000 bond, $50,000 bond, $2,000, whatever it may be, it's going to happen. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of any weapons as well. You're not to go back to Crunch Fitnesses also. Do you understand?
Yes, sir.
You pick up any more cases, violate even one iota of these conditions, I'm going to keep you with me. And I'm going to tell you now, it's going to be high. And if you don't have anyone to pony up that kind of money, $10,000 to get you out, you will be stuck like Chuck in custody until these cases are over with. And I'm going to tell you, it takes damn near 9 months just to get a 911 tape. Do you understand? How old are you? What do you do for a living?
I worked in catering, and then now I'm doing solar. So I'm a sales representative.
What kind of money you make a month?
I haven't made any money. Right now I'm living off unemployment checks because the money I had from my last job ran out, and the money that I'm making on my new job is all commission, so I have to close the deal before I have any income.
Who are you living with?
I'm actually living in my car at the moment.
Okay. I'll have you fill out an application for an appointed, actually, let me see your name. On this application, you says your spouse's salary is $10,000 a month. What does that mean?
My what?
It says under spouse's salary, $10,000. You make a total income of around $11,000 a month.
Did I fill that out? I didn't fill that out.
I'll have you fill out a new one then.
Okay.
So you're living in your car.
Yes.
How is that?
I mean, it's fine as long as it's not too high.
Sucks. Sucks to live in your car, doesn't it?
I mean, I don't have any money, so I mean, it's better than the street.
What I'm trying to tell you is that when you're living in someone's house, under their roof, don't bite the hand that feeds you, because
It was my brother that I got.
register what I'm trying to tell you, Mr. Jenkins. If you're under someone else's roof and they're kind enough to take you in, when you bite the hand that feeds you or burn a bridge, you never know when you may need to cross that bridge. Now you've burnt the bridge, you can't even cross that bridge, you're living in a car. Living in a car sucks. So be nice. It's not hard, especially when you're living under someone else's roof. It's not that hard. And if you get into an issue where you fight with someone or you're upset, walk away, find another release. Do you understand what I mean? It's not hard to be nice. Can I give me an application? I'm going to have you fill out this application because I need to know everything about you as far as money-wise. I'm going to have you sign a reset with Jermaine, and then I'm going to have you take a seat in the jury box where we get all your orders ready, and I'll find you a lawyer. Okay? Okay.
So I'll be on the court today?
Yeah, I'm going to have you talk to a lawyer today. So don't leave until I excuse you.